Funding for Current Conversations is provided by University of Oklahoma President's Office, University of Oklahoma Outreach, and World Literature Today. Welcome to Current Conversations. I'm R.C. Davis-Indiano. Today we're going to be talking about the U.S. Constitution, what it has meant to American society and culture, and what it still means to the American way of life today. Our guest for today's show is Professor Rick Tepker, who is Floyd and Irma Calvert Professor in Law and Liberty Professor of Law at the University of Oklahoma. He was the first OU faculty to argue and win a case in front of the U.S. Supreme Court. I hope you'll join us. Talking about the U.S. Constitution today, could we talk about it in some general terms just a little bit? And, from a lot of quarters, it really seems like the gold standard for setting up government and how a culture is going to be, where it's going to set its parameters. How would you describe the way we look at it?
Well, I think the first thing to remember, it was the first written constitution that has lasted. The written constitution idea was a new one when the American Revolution occurred, and the first written constitution was the Articles of Confederation. The constitution we have today was really a confession of failure. The Articles didn't do a good job. So initially it was basically a plan, a structure for a strong national government.
When it says to form a more perfect union,
Right.
Is that a reference back to the Articles of Confederation? We're trying to do better what they didn't do as well as they should have?
I think so. It certainly was
Yeah.
in the minds of Madison, Hamilton, and most importantly, George Washington, who was absolutely critical to the shift from the constitutional principles that had been cited in the Revolution, but really proved to be very impractical.
Mm-hmm.
And then the new Constitution was an attempt to make sure that the national government had adequate power to handle national problems.
Mm-hmm.
And that was the principal reason. So the first idea, the 18th century document, I think was an icon of competent, capable national government. It's also a 19th century document, and there you begin to see a transformation in the use of national power to promote civil liberties and civil rights. And the key for that is the 14th Amendment. Just last week, as we're taping this, we had the 150th anniversary of the ratification of the 13th Amendment, which abolished slavery. And that produced a constitutional revolution that really transformed the Constitution from a structural document we don't think much of these days into a source of a lot of litigation.
There seems to be a lot of skepticism, deliberate skepticism in the way the Constitution is set up, the separation of powers so that one, the judiciary, the executive branch, or the Congress, nobody really gets the upper hand, a kind of control chaos in a way. Does that come out of the Enlightenment, the 18th century?
Yes, I think that's Locke, Rousseau.
Okay.
It's the idea that the best government would be limited government. It's a consensus that Western civilization rests on individual freedom, economic liberty, and intellectual liberty. I think all of those are Enlightenment ideas.
So if somebody were going to see the Constitution on, say, a dry erase board, and you kind of look at its genealogy, there would be a lot of important documents that really lead into it. The Magna Carta, and lots of other things that establish this respect for individuality, kind of rational relationship to authority, all of those things. So
I'd hand it over to an impressionist painter rather than an engraver, because that would be too much to do it in much detail. You have to remember the Constitution is also a document of compromise.
Mm-hmm.
Different people had different visions. When they came together in Philadelphia, and then again and again before the Supreme Court, different ideas are clashing. So yes, they're influences, but they're also compromises.
I've read somewhere, maybe I was reading the Federalist Papers recently, and it talked about all the founders not just sort of getting together and talking, but basically sending away for books. A lot of them were reading up and reading about other forms of government, et cetera, kind of steeping themselves, cramming for all this. And it's kind of an exciting thought.
And particularly James Madison. James Madison had his own Monticello. It's called Montpelier in Orange County, Virginia, and they've just finished renovating it in a way that kind of restores it to the look that Madison had. And he had an upstairs library, and you could see the books that he went and got and all of the ways in which he planned and crammed. And I think he was the intellectual driving force in most of the Constitution's features and in the Constitution's defense in the Federalist Papers.
So this was really controversial stuff. These aren't just wise men sitting around expressing themselves and then it gets passed. They're openly arguing and debating.
Oh, yes, and it passed by a very thin margin. There's a wonderful book by Pauline Maier called Ratification, and it really describes beautifully the chaos, the controversy, the confusion, and the absolute inability to draw too much in the way of a conclusion that there was a consensus. Many of the compromises are essentially what many politicians understand today, punting the issue down to the road and hoping that it'll be resolved by a Congress or by a president.
Now, the original Constitution was ratified, what, 1789, 88, something like that?
1788 ratified. The national government created by that Constitution comes into being in 1789, primarily with the inauguration of George Washington and the sitting of the first Congress.
No, it's a pretty short document, right? Like 7 articles. Isn't that like the world's shortest Constitution or something like that?
Well, I'd be hard-pressed to know that.
Yeah.
I think that's probably true, but you're right. Basically, it's short, it's succinct, and it is hopelessly confusing. Even with its concise words, there are a lot of open-ended phrases there that cry out for further interpretation because they're so ambiguous. What's the meaning of due process? What's the meaning of equal protection of the laws? What's the meaning of freedom of religion? We debate those because these are not self-evident, self-defining phrases.
Now, a lot of those issues you were talking about that got punted down the road end up in the Bill of Rights and the 27 amendments that get added to the Constitution later, right?
Right. The Bill of Rights story is a story worth telling just briefly. James Madison, having crammed and drafted a structure, basically said, we don't need a Bill of Rights. The Constitution's adequate because of the checks and balances. We don't need these parchment barriers that'll be violated at will by majorities. And then someone who had been his political ally when he served in the Virginia legislature put his arm around him on a country road in Virginia and said, James, we're going to support your rival, James Monroe, unless you support a Bill of Rights. James Madison created the first great American tradition, the flip-flop. He flips over to supporting a Bill of Rights after having opposed it, and he drafts it in the first House of Representatives. That's how he got it. And he pulls a little here and pulls a little there, and boom.
Would it be fair to say that in the original 7 articles, there's a kind of structure of government being set up, and then the values, individual liberty, et cetera, are talked about much more explicitly in the first 10, the Bill of Rights, the first 10 of the 27 amendments? Would that be accurate?
I think basically. Yeah. The first document ratified in 1788 is primarily about structure. It's about the relationship between the national government and the states. It's about representation, creates an executive and a judiciary. The restrictions on the national power, some of them are procedural and some of them are substantive, are in the Bill of Rights. But for the most part, and this is one of the truths of American history, the basic rights which we take for granted were left to the discretion of the states and their own Bill of Rights and their own state judiciary.
That was one of the big arguments, right? Was the federal government going to be able to dictate to the states, or would the states be sovereign? And wasn't there something like co-sovereignty, the phrase that came out of it?
Well, there were arguments.
Yeah.
John C. Calhoun is primarily noted for amplifying the concept of state sovereignty. Dual sovereignty is probably the phrase that I think you're thinking of. But I think most of his analysis was an argument about what he wanted the Constitution to be, not an argument about what he thought it actually was. He rejected so many of the basic principles of the original Constitution. It's hard to say he was offering just an interpretation. He was really offering a political theory for an alternative.
I have read the Constitution before, and I'm a reader of the Federalist Papers, but I was going over this time. And it occurred to me that people don't read the Constitution anymore. Maybe in your world, in the law world, probably more people read it than in the general world. But I would say, by and large, it's an unread document. And that's kind of a frightening thought, because it seems like there's this invisible hand of the Constitution working all the time. And the way the press has this kind of adversarial relationship with Congress or the presidency, and the way Congress doesn't necessarily go along with what the president wants. All of this was pretty much scripted, right? I mean, they wanted there to be this sort of controlled chaos so that nobody gets the upper hand.
Boy, I was startled to hear that word scripted. I think there is so little in American history, even American legal history, that I would describe as scripted or predestined or even, made clear. Most of the script left open ambiguities. Our constitutional debates are usually about arguments over the sounds of silence. I'll give you one example. Can the federal government create a highway? Now, today we take that for granted. Dwight Eisenhower comes back from Europe and says, that Autobahn is a pretty good thing. We ought to have one. But it wasn't until the late 1800s that it was clear the federal government could create such a thing, until those issues were resolved by the Supreme Court. After the Civil War, the question of highways was almost always a state question. But there isn't anything in the document that actually says that. Nobody talks about highways in the document. So you're left with this churning, chaotic, paradoxical dialogue about how to resolve even so basic an issue as that.
But the minimalism that I think you keep referring to seems so important. The three branches of government, and that they can't subsume each other's responsibility, individual liberty, due process. It's not a whole lot of ideas, but they're very, very important, and they pretty much come out of that period. Those seem to be
They come out of the 18th century, strongly modified by practical necessity in the 19th century, and even more modified by the realities of the 20th century. The 20th century transformed the Constitution as well, because the economy changed and culture changed. The Congress of the 1930s and the 1940s was faced with challenges that Madison couldn't think of. Now, I think it was ultimately resolved with a principle that's compatible with the type of arguments he made, but not without considerable debate.
But the idea of conflict and friction, open competition in a civil society, that's the part they seem to have a pretty clear view of, though, right? They wanted that to persist.
Checks, balances, separation of powers, federalism.
Not too much power to any one entity or any one person.
Yeah. Break up sovereignty in a way that political theorists of the day thought was an impossibility, and spread it over as many hands as possible, so no one can get together and create a tyranny.
So a little bit of a cumbersomeness in the way it's set up, that it's all deliberate. Could you give an example of somebody, or maybe a situation that's testing the separation of powers? I think I've heard you talk before about 1952 and Truman. Would that be a good example?
Yes, it would be. In 1952, a case came before the Supreme Court that dealt a little bit with this. President Truman seized steel mills in order to keep them operating so they would produce steel, so other industries could produce tanks and other
Korean
armaments
conflict was
for the
just
Korean
about to
conflict.
happen. Yeah.
No, it had already happened.
Yeah.
It was right in the middle of the war.
Right.
And they needed to keep the engine going in order to maintain strong military force in a war police action, that had already begun.
Reasonable, motivations, yeah.
No declaration of war. The question was, could the president do it? Now, the president produced, through his attorney general, a pretty strong argument based on history, but it had no limits. It ignored the friction, it ignored the balances, it ignored the separation of powers. And the Supreme Court ultimately said President Truman was wrong. They did so in a majority opinion that isn't much read today. There's a concurring opinion by Justice Robert Jackson, who takes a somewhat more modulated and pragmatic view of these things. But the bottom line is, presidents don't have unilateral power either to initiate war or to do some extraordinary things outside the theater of war in the name of military necessity.
Like nationalize the steel industry and say the government now owns it, yeah.
Or temporarily.
Yeah.
He didn't nationalize it in the sense it now belongs to us. He just said we're going to run it until labor and management get together end this threat of a strike. Didn't matter. There was no provision in the law for seizure. That requires an act of a legislative nature, and the president doesn't have that power.
So this idea of the separation of powers, it's a kind of ideal in the Constitution, but basically throughout history, we're going to see sort of testing of those limits, somebody saying, well, what my responsibility, my authority goes further than people thought before, and then in that case, it was the Supreme Court's role to push them back and say, no, gone too far.
Right.
So that's gonna keep happening. The declaration of war just seems so clearly to belong to the Congress. Is this something that could face some kind of constitutional test at some point?
Well, it may seem clear in the text, I grant you.
Yeah.
But if you look to historical examples for the entire country's history, there's example after example of presidents using military force for various national security objectives. And so if it's a clear principle in the text, it's honored in the many, many breaches of the principle in real history. Jefferson, James Knox Polk in the Mexican War, Lincoln in the Civil War, Franklin D. Roosevelt selling destroyers to Churchill, Cuban Missile Crisis, Vietnam. It's really a very strong list of non-judicial precedents that make it clear that we expect our presidents to take care of crises. That doesn't mean the Congress doesn't have a role. It's their function, I think, to define the diplomatic state of affairs, and that requires, in certain circumstances, a declaration of war. When you don't have a nation that is causing you trouble, as in the case of ISIS, you have to do something besides a declaration of war. It requires a different set of words, but they still need to act and recognize the situation.
It sounds like you're complicating on purpose our model quite a lot. So if we're going to model,
I'm not doing that.
If we're going to model how to think about the Constitution, we put the Constitution on the table, and well, that's not enough. Put the amendments there. Okay, that's not enough. Is that enough? And I think you're saying, well, there's a whole long history of case law and Supreme Court decisions about the Constitution. Put that there. That's going to color it. History itself is going to color it.
But also practices.
And also practices.
That do not actually result in specific cases. Yes, I think that's part of the way in which our principles and our understanding of the Constitution are developed.
Maybe we could go to a current case and talk about this. As I read the 14th Amendment and equal protection under the law, seems like a pretty straightforward thing. And yet, I think about affirmative action and the way it works. And isn't there a case pending right now?
The Fisher case.
Fisher versus the University of Texas at Austin.
The Fisher case is the latest in a series of cases going back 30 or 40 years, asking when is it permissible to take race into account in order to eliminate the effects of past racial discrimination and racism. And you've got a few people, Justices Scalia and Thomas, notably, who say never, ever take race into account, figure out another way to do it. And you've got a larger group of justices over the years who say, no, sometimes in order to have an adequate range of appropriate remedial options to deal with race, you have to take race into account. Just now, the doctrine is very heavily pointing in the direction of the Scalia-Thomas view. But one of the questions in the current case is whether they're going to have a fairly absolute, categorical, uncomplicated principle, say no race discrimination by government at all.
Or they could send it back and say maybe we need more information, or a narrower ruling that just really pertains to Fisher versus Texas and doesn't have any implications beyond that.
Right. Those would not create headlines.
Right. What would the argument be for not ever taking race into account?
Well, I think there's a very strong theoretical argument in favor of that. The text, the whole principle of race discrimination, the history of race discrimination suggests that we don't use race very well in any of our decision-making processes. But it's a theoretical argument matched against an argument based on reality and practicality. Sometimes to eliminate racial discrimination by a decision maker, you have to set up an objective standard of behaviors that it can only be measured by whether or not racial preferences are actually occurring and racial discrimination is actually occurring. And the usual response of most civil rights agencies is to have a limited, careful role for racial preferences in remedial efforts. Now, I know those words probably don't add up to much clarity, but that's partly because the Supreme Court has rendered decisions that are themselves compromises. And I point out one other thing out. The phrase equal protection of the laws doesn't really give us much in the way of textual guidance for resolving it. Now, Justices Thomas and Scalia say they're originalists. The truth is, there isn't any clear original understanding surrounding that phrase that says no to affirmative action. The closest thing you've got are pieces of legislation passed at the time the 14th Amendment is being considered in favor of a Freedmen's Bureau, which provided social services solely to former slaves in hopes of integrating them into society. Because we did that job so badly and have done it so badly over the years, there are still remedial efforts that must occur.
Let me test whether I get this, the argument that you're talking about right now. A theme I've seen a lot in legal documents is this sort of viewpoint neutral goal. And I think this must go back to the 18th century notion of the categorical imperative. Take some contract and then elevate it so that that applies to everybody and look at the results. And if you can't apply it to everybody and you don't like the result, it's not a fair application, then you probably don't want to stay with it. So there seems to be a goal of trying to set something up so that you could say, always in all cases, this is what we're going to do.
Well, I agree that neutral principles are an important ideal in the law. But it's awfully hard to actually follow that motif through litigation and apply it in a real-world case.
History's on that table, too.
History's on that table. Evidence of what would or would not happen with a particular judicial ruling. But I agree with you, when the court's doing its job right, the law should not be about whose ox is being gored.
Mm-hmm. I mean, if you're anticipating who's going to be offended by a particular action, what I've seen so often is the court backs up and says, no, don't go that direction. Set it up so that it's viewpoint neutral. Works for everybody.
The viewpoint neutral throws me off. That's more a term that I think comes out of First Amendment analysis than equal protection analysis. But there is this separate concept called neutral principles that I think does appropriately describe what you're talking about functionally.
So now the case that you're talking about, Fisher versus the University of Texas, that has been argued in front of the Supreme Court and twice, and we'll get a ruling on the current argument when?
Before June.
Before June.
Or June 30th.
Okay, so affirmative action seems to be actively on the table, and we're rethinking that. Freedom of religion or protection of religious rights, isn't that another one that seems to be pretty prominent out there now? A lot of cases are going through the Supreme Court dealing with that.
Yes, and I think a special issue associated with that is how do various measures designed to promote racial equality, gender equality, or equality based upon sexual orientation weigh against free exercise rights and freedom of religion. And that's going to be an issue over the next few decades. It's going to produce a lot of cases.
There's a case, and I don't know if this has constitutional implications, but Zubik versus Burwell, isn't that like a consolidation case? There are, in fact, a lot of cases that will be affected in the way the court rules over Zubik versus Burwell. Would you talk about that a little bit?
Well, it depends on what they do, but yes, your viewers might know it better by a different name. Society of Little Sisters, Home for the Aged. And boy, it takes a long time to tell the whole story. First of all, this is an outgrowth of the Obamacare issues. But more generally, it's an outgrowth of an idea going back to the 70s that women deserve equal compensation for their work. And equal compensation requires good medical benefits through an employer plan. Healthcare. And that includes preventive care, which may include birth control. Unfortunately, some employers, primarily nonprofits, object to being forced to pay for birth control on various religious grounds. The Supreme Court has said they have a legitimate concern there based upon the Religious Freedom Restoration Act. Having lost the case, the Hobby Lobby case, the Obama administration arranged Obamacare to provide the services to the women without cost to the employer if the employer cites their religious reasons. Right now, in this case, basically the employers are saying the requirement that they claim a free exercise right is an undue burden on their religious freedom. Historically, that argument, I think, is laughable.
And the Obama people are saying, how do we know that you have a problem with it unless you tell us?
And free exercise traditionally has said it's up to the person making the claim to prove the sincerity, authenticity, and centrality of their beliefs. So I think they're going to have a hard time writing an opinion for the Society of Little Sisters, as harsh as that may sound. But I think we're so politicized right now that I don't know how the case is going to turn out.
We've only got about 30 seconds left. I want you to make a fearless forecast of the things we've talked about, or maybe something else entirely. What do you think is going to appear on the horizon and is going to be problematic, probably dealt with by the Supreme Court several times, that people could look forward to?
I think the events of the University of Missouri this year and University of Oklahoma last year point to conflicts between freedom of speech and the duty to maintain equal educational opportunity, and it's going to put perplexing puzzles in the face of university administrators and faculty and judges for as far as we can see.
We'll get back with you and check on that later.
All right.
Thank you very much for being on the show. I'm especially glad that you could be with us today. Please join us next time for more current conversation. Thank you for watching.